Please take your seat, stay closer to us. We are ready to start. Don't be shy. It's not a university audience, university class. Don't be afraid. Sit here in the first rows. Please take your seats. In a few minutes, we will start. We're still waiting for a few colleagues who are, despite all the weather conditions, coming.
Отож, доброго ранку.
So once again, good morning, everyone. Let me introduce myself. My name is Tatiana Oleksiyuk. I am the Council of Europe expert and Vice President of one of the monitoring bodies of the Council of Europe, responsible for the implementation of the Council of Europe Convention on Access to Official Documents, the so-called Tromsø Convention. Today, I am extremely honored and pleased to open this event dedicated to the International Data Protection Day. Today in the morning, I was just thinking about the fact that the 28th of September is the day of access to data, and the 28th of January is the Data Protection Day. So there is something about this date 28. We can find the right to protection of personal data and the right to freedom of expression in the respective articles 8 and 10. And indeed, European community pays a lot of attention to the personal data protection. I would say it's a core of European community, European democracy. It's all about making a person, its personal space and rights in the center. If we compare it to the autocracies, they do not put these rights in the center at all. The European community is different. The Fundamental Freedoms Charter of the EU views personal data protection as a cornerstone of all the European institutions, all European regulations, and even this acronym GDPR, which might scare some Europeans, shows that whatever goals, business goals we pursue, whatever alliances we establish, the main thing is personal space, unique, personal, important, and protected personal space. So today we will talk about this important right, but we will also keep in our mind another different right, the right to freedom of expression. Media is the main democratic tool. Media talk about and for people, and there always will be a person, an individual in the center of all communications. They always mention those who take decisions and why they do it. So media convey information, including personal information about people, about those we build our country and community with, about those we interact with, and shape some values with. Today we will also discuss how the media should take into account personal data protection. Where to find the balance, how to strike the balance, where are the practical solutions, when we have to know about certain facts, but also respect the privacy rule. Everyone would like to have some privacy, so how to strike this balance, how to find the right proportion. So to find out and see how European values operate in our society, which faces a lot of dangers, we gathered here today. The key role of our today's event will be played by the National Human Rights Institution, the Office of the Verkhovna Rada Commissioner for Human Rights, and it's very important to hear from them what we can do to find this balance between freedom of expression and personal data protection, despite all the challenges. Has anything changed in this scheme since the start of the full-scale war? The answer is yes and no. Actually, I am incredibly proud that despite 4 years of war, Ukraine remains in this democratic framework. Talking to the colleagues from European countries, I would say that not every European democracy would maintain a balance. I think we have maintained it. However, we also realize that the price of mistakes is very high. So that's what we're going to discuss. So where are those risky points, what we should pay particular attention to, what we should discuss to understand what are the rules we have to respect when it comes to personal data protection. And now I am happy to pass the floor to Yulia Derkachenko, representative of the Commissioner for Human Rights of the Verkhovna Rada of Ukraine for Information Rights. Good morning, dear colleagues, dear participants of our today's conference, media representatives, journalists, experts, national and international ones. Today, I am honored on behalf of the Verkhovna Rada Commissioner for Human Rights to congratulate you on the International Personal Data Protection Rights, and I would like to say thank you to the Council of Europe project and GIZ project for organization of this event, for support they provide to Ukraine in European human rights standard maintenance in Ukraine. And I would like to say thank you on behalf of the Verkhovna Rada Commissioner to you, dear journalists and media community representatives, for your everyday work. You inform the society, you help fight disinformation. At the same time, you have to respect this principle, do not harm and do not violate privacy. The Commissioner of the Verkhovna Rada and the courts oversee the respect of personal privacy. At the same time, we do not control the activities of journalists and we do not limit the freedom of expression. According to Article 34 of Ukrainian Constitution, the freedom of speech is guaranteed. At the same time, Article 32 of the Constitution of Ukraine guarantees the right to privacy. So today, dear colleagues, we will talk about the correlation between the freedom of speech, the right and the right to privacy, and we will think about this balance we can find without restricting the freedom of speech of the journalists. And media bear particular responsibility while they work with personal data of people, and the task of the government is not to limit in any way the journalists, but again ensure the balance between freedom of speech and the right to privacy. So it's a great honor that today the National experts in the area of data protection have joined us, as well as the expert in the area of access to public information, and we've been supported by international experts and organizations. So I would like to invite Ms. Hilde Haus, Deputy Head of the Council of Europe Office in Ukraine, to take the floor, please.
I'm sorry, many travel angliska ju vara riktigt. Good. I wanted to say, dear Julia and their partners here today, we also wanted to welcome you on the behalf of the Council of Europe to this event, and also marking this International Data Protection Day, which was established back already in 2006 by the Committee of Ministers. And it's also celebrated worldwide, so it's not only in Ukraine. And this day also serves to raise awareness of the vital importance of the protecting individuals' privacy and to highlight the essential role of the Convention 108, which is also meant to safeguard democratic and societies from excessive intrusion by public and private actors. And I think this is also very relevant these days, as you see. And building a secure digital future also requires institutional framework capable of delivering concrete solutions for a wide number of stakeholders. And in this regard, Convention 108, which is a legally binding international instrument on data protection, also sets a global standard for compliance and for multilateral cooperation to ensure that your rights to privacy remain protected. And to address both the new and also emerging challenges and the ones that already existed, the Council of Europe works also closely with other actors to implement a modernized version of this Convention 108, which is called Convention 108 Plus, and also to ensure that data protection remains robust, but also forward-looking and also fit with this current kind of climate and digital age. And also in terms of, coming back to Ukraine's role here, Ukraine has already taken a number of significant steps to implement into the reforms that it's required for its further European membership. But also in this regard, the data protection is a very important part of this journey. And with the support of the Council of Europe, Ukraine continues at the moment to try to align its law and practices with the modernized version of the Convention 108 and also to the EU General Data Protection Regulation. And I think there has been already substantial progress made in recent years in regard of both of these regulations. And I wanted to mention there are like two draft laws that are now, both of which are now being registered in Parliament. One called on personal data protection, and the other one on the National Commission in the field of data protection and access to public information. It's a bit of a long name, but and their adoption would also mark an important step to demonstrate Ukraine's commitment to implementing the recommendation of the European Commission. So I hope there will still be some progress seen on this aspect. And I think it's a very timely, this focus on the media and data protection that in this year's conference organized under the Ombudsperson's initiative. And as it remains, I think, as you already mentioned, a crucial, important for every society, but especially at this time in the challenges of war. And I think it's good to see today so many different colleagues here from different media organizations and journalists. And I think our aim will also be to continue to work together to examine the risks of human rights violations arising from the processing of personal data in the media and in the digital environment, as well as to look at mechanisms for preventing such violations when it comes to international standards. So I hope we will have a chance today to also discuss all of these issues in an open environment with a lot of active participation. And I just coming back to Council of Europe's role, I mean, we also have been playing an instrumental role in shaping the standards on data protection and privacy, including also in this media sphere. And I think one of the most pressing challenges in today's data-driven environment is to find, as I think you already mentioned, this balance between the freedom of expression and the right to privacy. So I think that's something that is difficult, but I think it's also very important to look at. And balancing then this creative content with also having some strict adherence to data protection rules, I think it is important. It's not just a legal obligation, but it also affects public trust and audience engagement and the sustainability of media organizations. The media in this regard also plays a vital role when it comes to informing societies, and how this responsibility must be exercised with care, ensuring that reporting on personal and sensitive matters respect also the individual dignity. And when it comes to ethical journalism, supported by professional codes of conduct and self-regulatory mechanism, this is also especially important when you cover a lot of sensitive issues like crime and conflicts and other issues that are of a sensitive nature. And in this digital age, the protection of personal data adds another layer of complexity, which also requires the safeguard of privacy, but without undermining the vital function that the free and independent press, of course, also has. So again, this balance, I think, remains very important and also difficult. So I think to assist journalists in finding the appropriate way to apply data protection standards in the daily work, the Council of Europe has also developed a set of guidelines on safeguarding privacy in the media, and I think you've probably been working a bit with us also on these issues. And these guidelines are based on the standards of the Council of Europe and the case law of the European Court of Human Rights. And they are intended more as an advisory tool rather than kind of like a prescriptive set of rules. So it's more like a guidance to help you maneuver in this landscape. So yeah, and you are of course encouraged to use them actively, and also we are also we'll be very grateful to also get some feedback as these guidelines remain open to further development and future improvement. And I think as fast as the media landscape is developing, it would be also very helpful for us to kind of learn about some of the other challenges that you have and what can be improved when it comes to these guidelines. So I really hope that this will be a good discussion today, that they will inspire you to act with integrity and that also still be room for innovation, and that we will continue to build a media environment that is both trustworthy and free. And that working together, I hope that the media can remain also a force of transparency, accountability, and for the protection of the fundamental rights that we all should have in our ever-evolving digital world. And the Council of Europe also very much stands by you to support in this aspect. So with this, I also wish you a good further discussion today. So.
Thank you, Hilda, for this support and very good and warm words. Thank you very much. So please let me introduce the incoming introduction word of our international partner and representative of international partner Sandra Fur, regional manager of a regional project of GIZ, reform of state management in Eastern countries partnership. She is online with us. If it is possible, please put her on the screen. Sandra, can you do it? Yeah, thank you.
Hello, good morning. Thank you very much. I hope you can hear me well.
Yes.
Yes. Thank you. Well, on behalf of GIZ, I'm the project manager for the regional project Public Administration Reform in the Eastern Partnership. And on behalf of GIZ, it is a very great pleasure for me to welcome you to today's conference. And I would especially like to thank our Ukrainian partners who are here in such a large number. From really the bottom of my heart, I would like to express my gratitude and admiration for your commitment and your strength and for defying the daily terror inflicted by Russia. In these times of terror and the resulting martial law, it is so important that our values and rights and legislative laws governing the use of data, personal data, are upheld and protected. And the media here plays an important role in this process because they shape public debate and inform the society while increasingly working with large amounts of personal data. And strong data protection supports freedom of expression, responsible journalism, and in the end, also trust in public institutions. As GIZ, financed by the German Ministry for Economic Cooperation and Development, we, and I promise you, remain committed to support Ukraine in aligning its data protection framework with European standards on your path towards the EU accession. We will continue to do so in close cooperation with our international partners. And here I would like to express our sincere gratitude for the constructive and trust-based cooperation we have had with the Ombudsman Office in the field of personal data protection since 2022. We highly value your and our joint efforts to strengthen institutional capacities through continued support in different formats. We also appreciate the close cooperation with European partners, including the European Data Protection Supervisor's Office, the European Data Protection Board, and also the data protection authorities of EU member states, as well as now growing cooperation with Western Balkans data protection authorities. These partnerships support knowledge exchange and help align legislation with EU standards. I want to keep it short by here and really thank you on behalf of GIZ for this fruitful cooperation and this partnership. I'm looking forward to many more opportunities like this to work together. Thank you.
Щиро дякуємо, пані Сан.
Thank you very much, Sandra. And dear colleagues, we have a video greeting from our colleague from please, sorry, Wojciech Bewiorowski, European Inspector for Data Protection. Please put his greeting on the screen.
Dear colleagues, dear friends, I'm delighted and honored to join you for this conference through the video message. Unfortunately, I cannot be there myself. We are organizing the EDPS conference for Data Protection Day in Brussels. I would like to thank all the organizers and in particular the Ukrainian Ombudsman's Office for this opportunity. This conference is of great importance, not only because of the significance of the topic that you are discussing about, but also because it demonstrates the unwavering determination of Ukraine to turn towards the European Union, Council of Europe, human rights standards, including the field of data protection. That was always obvious for me since 2012, where I first time as the Polish Data Protection Commissioner had the training sessions in Kiev. I can see this difference in the approach to data protection. As already said by the President of the European Commission, Mrs. von der Leyen, Ukraine joining the European Union is the greatest guarantee of just and lasting peace. In our history, peace and European integration have always gone hand in hand. As the part of accession process, countries seeking to join EU must implement reforms in order to align with EU laws and standards, also known as acquis. The European Commission already welcomed that Ukraine has demonstrated an impressive capacity to deliver reforms, even during the wartime. And data protection is an integral part of this discussion. I hope that your new data protection legislation, setting up an independent data protection authority, will soon be adopted and fully operational. We had the chance to listen updates on this process last December when the Ombudsman's Office was present at the Data Protection Week in Brussels. That was part of our cooperation with Eastern Partnership and Western Balkans. On the occasion of Data Protection Day, that finds its origin in Convention 108 from the Council of Europe, I can only call for a swift and rapid entry into force of the modernized Convention 108. 5 ratifications are still missing for the entry into force of this instrument that has its potential to become the global standard for data protection. Freedom of expression, pluralism can and have to go hand in hand with respect to the privacy and data protection, as also recognized by the European Union's General Data Protection Regulation and several instruments of the Council of Europe. We all need, in the EU, in Ukraine and beyond, the comprehensive framework to help us to face current threats to our democracies, so that personal data can continue to be used in the knowledge and confidence that individual rights to privacy is respected. I would also like to commend your courage and resilience under wartime conditions. It's exactly in these troubled times where safeguarding personal data can help to build resilience, whether it's be against breaches resulting from the cyber attacks or other hostile activities or online manipulation. Happy Data Protection Day to all of you. I wish you a very fruitful discussion today. And chwała Ukrainie.
Героям слава. Ще раз хочу сказати слава.
Once again, I would like to express the words of thanks to our international experts, international partners for support of Ukraine, for support of the Office of Commissioner in the field of reforms for the protection of personal data. And please let me introduce some results of the Office of Commissioner for Human Rights in the field of keeping to information rights and the rights of privacy. Please, if possible, I have 3 slides. I would like to present you the results of this work. So I can do it. Please assist me in switching. So please put this presentation on. So thank you a lot. Dear participants of the conference, please have a look at the screen. And you see the results of the work of the Office of Commissioner for Human Rights in 2025. The Commissioner received more than 15,000 requests in the field of violation of human rights, and we received the messages about the privacy breaches. So this is the main data of the Commission according to the law of Ukraine for protection of personal rights. In 2025, we had 104 inspections in 76 state companies in the local self-government companies. There were decisions for removal of effects of breaching of personal data, and there were 36 cases initiated, and the law enforcement bodies started criminal cases, and they put the data in the register of pre-trial investigations. We also introduce and perform educational work. We all of us know that Ukraine wants to be integrated in Europe and be part of Europe. So since 2022, we started an official information campaign in the protection of personal data, and then we started an official campaign after the results of the screening of the legislation, and especially in the field of right of privacy. And accordingly, the war changes the rights the conditions of life, but it doesn't change the right for dignity and for privacy. Personal information is not information only, it's human fate and people's lives. So we can say that protection of incorrect keeping of personal right can have tragic influence on the people's life. So together with the Office of the Commissioner, we developed recommendations which I keep in my hands, and you also have it in electronic form. So in these recommendations, we tried to help the representatives of the media, the journalists, and not only these categories of stakeholders, but also the state authorities, the local self-government bodies, those who publish personal data, who put this information in social media on websites of the state or private websites. All this information, thanks to these recommendations, this information can be placed without violating the rights to privacy. So we understand that these recommendations, it's not a prohibition, it's the help to journalists to protect the rights, human rights, the rights of the person and the rights of the citizens, first of all. And let's not forget that these recommendations, they are the advice, not the prohibitions. And we are pleased to use them ourselves when we disclose information of our activity. So also, please, you can find out about other recommendations in the keeping the right to privacy. So through the QR code, we have the brochures, we have recommendations on 9 fields of activities of the Commission for Human Rights. So we should understand the right to the privacy. It's not the prohibition, not at all. It's not the prohibition, the right to speech, but the freedom of speech and right to privacy. These are the two columns that match both together, and these are the tools of the democratic society. So thank you for your attention, for your coming here. And so let's start the first panel, and we'll give the floor to our moderator, Tatiana Alexeyuk. Dear colleagues, thank you, and dear Yulia. So we can continue to discuss it, and I would like to invite the panelists for the first discussion. I invite Lilia Oleksiuk, if she's here. So Yulia Derkachenko, Ganna Krasnostupa, and Tatiana Avdeeva, please take your seats in the panel discussion. Unfortunately, the weather is not so good today, and the road is not good. So Lilia will join us she's on the way, I'm sure, and we will start and discuss the institution frames in the field of personal data and in the field of right to expression. Any European regulatory act, if you look at it, how it started from the strategy and goes to the regulation and the directives, and so any European act is oriented at two frames. How to regulate it on the level of substantial right, and which institutions should assure the implementation of these norms. So I will be honest with you. I will give the floor to the panelists. When I read the European regulatory acts, sometimes I feel pity for Ukrainian right defenders. I feel pity to Ukrainian right defenders. They are not ready for such tests. So when you read these acts, you just lose this feeling of Ukrainian regulatory acts. So in European acts, we have a lot of broad definitions, explanations why it is so and not so. So I ask my students, when you read the Regulator Act, what did you see? The preamble was very long. Yes, it could be twice as big as the act. So we are in the process of harmonization with acquis communautaire, with field of law of European Union. So it's very important for us to merge the Ukrainian legal acts with the framework of Europe to which we want to join. So it's very difficult task for us because European countries they entered step by step, but we wanted to be faster. Ukrainians do always everything faster. So there are plans to be harmonized with the key communautaire until 2027, and all of us as national experts and international experts, we work on this. So I will start this first panel with the question to Lilia. So you just enter. And I will ask first of all Lilia Alexiuk, as the national expert for protection of personal data, way she sees Ukrainian legislation in combining with GDPR, and what are the exclusions are for the journalist. How do we read the GDPR here and there, and how it will transform, and what an advice we can give the journalists how to use it correctly. Please, Lilia. So thank you, and I'm sorry for just breaking into like Ukraine into EU almost, but these are our realities, and the road was blocked. People don't want to go to the front line, but and we should agree with this. We can do it sensation and the tragedy, but I look at this in philosophical way, because people go to the front, and we should share this pain and do something to enter as fast as possible to EU. So in my opinion, it's the only way to survive in this situation. But to enter there, we should do a lot of homework, how to behave not only with the data, but with a person, with a human. First of all, when we speak about the personal data, about privacy, it's first of all the continuation to work with respect to the person. Nobody likes when someone is touched by his or her hand without permission, and especially people don't like when people do some manipulations, let's say medical, without preventing a person. So why should people enter your life without any grounds to announce to the world the details of his or her life, or my life? And I consider that we should grow up a bit here.
And I think we have to do this homework of ours and define what are this line between privacy and public interest. Our current law on personal data protection in Ukraine establishes not only some exceptions for the journalists or people who work in the media. So these are not only journalists, but also bloggers and those who convey some thoughts to the public on digital platforms. So when we talk about these things, we have to understand that our laws provides for some exceptions. However, if the balance is kept between public interest and privacy, what does it say us? For example, I am politically exposed person, a former public official, and I cannot expect a bigger privacy than an ordinary person who should not inform or open too much information to the public, because there is no need for that. A journalist has a right to inform the society about anything related to my professional activities or public activities, my engagement in society, but everything related to my private life should be communicated only with my agreement, with my permission, or if it is of public interest. For example, if my husband weren't serviceman but was evading military service or spending too much money, more than expected for an ordinary Ukrainian, of course, journalists would be entitled to publish this information. But the fact that his weight is of a certain number of kilos or the underwear he wears is not of public interest. Moreover, I am the public official, former public official, not him, and he has right to privacy. So every time such information is published, our regulatory acts of Ukraine state that there has to be respect towards certain categories of people. For example, the law on media establishes certain respect to children and information about children. Today, Ukraine has a martial law and military actions ongoing, and of course, certain children have to be more protected, and we have to think several times about how to communicate the fact that some children left occupied territories or the fact that their relatives stay in the occupied territories. These phrases that are actually true and maybe are of public interest can be dangerous, can present a physical danger for this specific child. So it's no longer just about loss of confidentiality. These people might be in a situation when there is a threat for their life and health, or a threat for their relatives who stay in the occupied territories. So talking about specific cases in the context of personal data and how the media cover this information, do you remember Bucha events in the beginning of war, and that famous hand with red nails, and the relatives found out about the death of their relative thanks to this photo. Who would like to experience the same as these relatives? I won't even ask this question. Yes, it was a hand of that person. So formally, it's not even personal data, but the respect towards the relatives of the deceased person who had to be maintained, and we had to think several times before journalists published this photo. I often see how journalists publish photos from attacks from the sites after attacks without blurring the corpses, and of course we want the whole world to know what's happening in Ukraine and be aware of the crimes committed in this territory, but there are probably a lot of people who wouldn't like to appear on such pictures. So in the European countries and in the Ukrainian legislation, there is this phrase, the balance between public interest and privacy. When a journalist, before they publish certain information, think beforehand whether it might present some harm for the people whose pictures they publish or their relatives. We also have a law on burial and on the deceased people, and it establishes that the data about the deceased people is always confidential. And one more thing I would like to mention, of course I can talk about personal data for a whole day, but there are two other issues I would like to bring up today related to media and personal data. I wrote it at some point on Facebook. There was a court judgment in a case when a person sent a nude photo to someone else and was brought to criminal liability for violation of constitution, and that was a court judgment. I was very surprised, but it appears that the public media and Telegram channels are considered as media by the court, and that's why the conclusions were like that. So there are some issues related to violation of personal data and privacy that might not be obvious. There is Article 182 of the Criminal Code of Ukraine, and the article related to prostitution also include this aspect of personal data protection in the sources. Why am I referring to Article 182, and why is it actually not relevant today? Because after we introduce the law on personal data protection, we suggest to pass to the personal sanctions, and the most painful thing will be loss of money and reputation, and not the leverage of certain law enforcement, so-called law enforcement officers. So if we consider the scale of things we will have to adapt once we adopt the new legislation, in particular the preambles related to certain EU norms, we have huge changes ahead of us. We cannot say that we are very advanced now from the point of human rights or democracy. We have to acknowledge that there are some issues, especially when it comes to the right to privacy. Even some of my students sometimes ask, who needs that? Everything is transparent now. There are cameras everywhere, at every corner, every building, and I always ask them, would you like a camera to be installed in your bathroom, or does anyone need the details of how you go to the toilet? So it should be a proof of transparency, or maybe it is something we do not need. So when we are talking about the limits of transparency, we have to rely on common sense, not even the norms that should be formally respected. And the last point, I would like to share my personal story to wrap up this speech about media and publications. A few months ago, by the way, the statute of limitation has already ended, but a certain false information was published about me, and those who were sharing this post knew that this information was not true, and they tried to share only the true parts of the post. So I could draw several conclusions of that situation. It's strange that intelligent people don't even bother to Google and check whether information is true. It also appears that media distinguish between two categories. First, they look at what bloggers publish, and media are not responsible for what is shared on their platforms when the bloggers are the source of information, and all the rest is subject to editorial policy. So that's why we have so many unofficial sources, unreliable sources, which give start to false data, which can be picked up by artificial intelligence later. So that was my case. And when I teach communication policies and strategies related to privacy, I always say that, of course, we can explain a lot, or we can just stay silent, and in 2 months this information will disappear from all the newspapers and news outlets, because we live in the world when the news the titles are more important than the content, and there is a lot of homework to do. The media and those who deal with privacy in general, the Office of the Commissioner for Human Rights do a lot, and I would like to thank them for the whole previous year, because they did a lot of job when it comes to the spread of information, access to public information, open data and privacy, and they set certain tasks, and they should not paralyze anyone's work. So thank you for your attention. Maybe I haven't mentioned everything, but I am ready to answer any questions. Thank you, Lilia. You did provide an outline. Our audience maybe needed. We can refer to GDPR, but the point is how we implement it in our reality for it to highlight the role of an individual and his or her privacy. And I actually planned to pass the floor to Yulia Derkachenko, and I wanted also to mention the role of the commissioner in protecting the right to information. We know that the commissioner exercises parliamentary control as opposed to criminal and administrative liability. The commissioner has different tools. They are in some respects probably more flexible and more useful. There are a lot of educational events organized by the Secretariat of the Commissioner, and every time when we meet with regional representatives of the Commissioner, and especially public, local authorities representatives, we always discuss the topic of personal data, how to honor the memory of the deceased soldiers, what photos can be published. Some charitable foundations want to provide financial assistance to the families of the soldiers, and the members of local councils then have to disclose personal contact details of these families. And I know for sure that the commissioner and the secretariat of the commissioner has to deal with all of that every day, explain why certain things are allowed and others are not, and what should be done to avoid such mistakes in future. So, Julia, where are we heading in the context of institutional framework? This is a question which is there for the last few years, and we are awaiting for the establishment of the commission, and we keep doing that work for now. Please tell us more about it. Thank you, Tatiana. Indeed, the commissioner has the oversight functions in the area of personal data protection, and Article 22 sets these functions of oversight of the commissioner. We should also remember about international and European legislation, which provides the grounds to protect privacy, the right to privacy. We, as a country which aspires to become a EU member state, we have to introduce all the European norms, but in the Constitution, we have this principle of privacy protection and freedom of speech protection, and the European Convention also includes 2 articles which correlate between one another, and they relate to the protection of freedom of expression and protection of the right to privacy. Of course, the national legislation was drafted back in 2010, and many things changed since then. We have the general regulation adopted in 2016, and it became effective in 2018. Almost all IT companies operating in Ukraine take into account this GDPR, and all the privacy policies are adapted to it, and most companies correspond to European standards. But we have currently 2 draft laws in the parliament. The draft law on personal data protection, which is voted in the first reading and is prepared to examination in the second reading, and we have the draft law on national commission in the area of personal data protection and access to public information. And this independent body will have all the powers when it comes to personal data protection and access to public information. You might ask, what is wrong with the commissioner, with our institution? But sometimes we realize that the functions that the commissioner has are not natural for the commissioner. For example, the function of oversight and the function of applying administrative liability. I would like to say that in 2025, the Commissioner received over 152,000 of applications, and you could see on the slides that 10% of these requests were related to the violation of information rights. And this figure is huge, and certain part of it, certain share of it relate to violation of information, personal information privacy, and we tend to apply sanctions, administrative sanctions to those who violate these principles. And we have to understand that the Office of the Commissioner is an independent institution, independent human rights institution, and its priority is to restore the violated right and awareness raising.
Only through this educational work we will be able to achieve these results as we have them now. If we move forward and we understand that we have a very good personal data protection law, and we understand that it's a bit old. In 2010, we have 16 years that passed, and there are some, as Lilia said, the article from Criminal Code which doesn't work almost, and in 1 year we initiated and opened, and the National Police opened 35 criminal cases, and we don't know where they are going. These cases will be their sentences under Article 182 of Criminal Code, or there will be no The same situation in the field of administrative violations. We lose our resources to establish the protocols, but unfortunately these protocols in the court proceedings, they die, sorry that I say, they die because the case is considered as a small importance, or the term of validity expires to bring the violated to responsibility. But anyway, when we work, we continue. We see that we read the post of our journalists, and so we see that the Office of Commissioner didn't work enough. But we have a lot of problems. Why? We don't have the right to complain about the court decisions. The judge decides it is not important, the case, and the term of validity expires. It does not use the responsibility to the functioner. What we have no right to complain about this decision, and we continue to work to re-establish the rights of the applicant, and we try that the state authorities and law self-government bodies, they would provide this information which is required by the applicant. They will keep the right to protection of personal data. They will delete the applications, create conditions not to validate not to violate the rights, and we always speak about the right to privacy, and what we achieved with our national experts, with our team of the Department of Monitoring of keeping the information rights, and we tried to develop the recommendations for these vulnerable categories of citizens. If we look at the military, we see that the spreading of personal data of the military in the website, in the articles of journalists, in social media. We see the passport data are published, and identification codes, place of stationing of the military, and nobody is responsible for this. Really, the Commissioner Office reacts, and the Office of the Commissioner monitors this information. We react, we make requests, we make applications to the national police, and of course these bodies, they react. Also they initiate criminal cases. Also the violation of right to privacy of IDPs, the people, war prisoners, and people who suffered from the violence. Of course, even bloggers can disclose their personal data everywhere. They disclose the photos of the passports, driver's licenses, and it's not possible to delete them, because in social media the Telegram bots, they are created anonymously, and there is no possibility to stop this activity. It's not possible to stop it. So please, dear media and journalists, take care about the right to privacy of every citizen of Ukraine. And if you see in this publication there is information about the passport data, or vulnerable information, information about the children, or what can be sensitive information, anything about the education, place of residence, or maybe even a geolocation, please do not spread this information. But if you want to repost this information, please blur this information and then spread it in an anonymous way and depersonalized way. And besides what I said, I wanted to point out that in 2024, during the official screening of the legislation by European Commission, I represented Ukraine in the field of personal data protection in Brussels, and the recommendations resulted that the Commissioner became the responsible for protection of personal data. What does it mean? It means that we are fully involved in the process of reforming of legislation of personal data protection in maximum way. We try. What were the steps? The first, we developed a roadmap where it was clearly said what are the points, sub-points in the legislation for personal data protection. And we have the ambitious goal until 2027 to reform our personal data protection legislation. What do we do? The Commissioner's office fully readjusted its work, and since 2025 we started, I don't like the word for some reasons, full-scale, large-scale information campaign, but we were transformed fully in the educational portal. So you know that the Commissioner created the regional network. In every region we have the offices of the Commissioner, and these are the bees that help us to make inspections, have educational events in the field of protection of personal data. And together with our team, the results, as you saw, these are the common results of our team, and the Department of Protection of Information Rights that is in Kiev in central office considered the applications about protection of personal data, but the application for protection of information rights, and we are supported by the regional representation offices. So we considered more than 4,000 applications, and in the field of information rights, we considered more than 11,000 applications. And together with our international and key partners, the Council of Europe and GIZ, we do colossal work in the education. So we modernize the course on protection of personal data. It's free. It's on the Intera platform, so please use it. There are two options of these courses for newcomers and for the state offices and for protection of personal data. So we developed an educational course, and we put it on the education platform. This is a professional course for citizens who wanted to develop their skills in protection of personal data. And in case the legislation is modernized, amended, it will be improved because we try to make it in the maximum way, so the citizens of Ukraine will be capable to become the persons who develops these and processes these personal data in every institution and every organization in the local government bodies. So also I would like to point out that we publish a lot of methodology recommendations, lots of explanations, presentations. We run educational events, and we accept the request to run these events. Of course, for us themselves, it's difficult to perform them. We are assisted by our partners. We have the Secretariat of the Commission in the Verkhovna Rada, and our goal is a European integration and reform of a system of personal data protection. So thank you for your attention. I give the floor to the next speaker. I will get the floor as a moderator. And thank you, Julia. And when I was listening to you, so there was a proverb: the one who carries, he gets the biggest load. So previously there was the public prosecutor's office who protected the personal data, and it was like in the sand. The complaint went there and disappeared. But the commissioner and his secretariat, they are very modest. With such modest resources, they try to cover all these things, and even people who don't need to go there, but they go there to complain, because the commission is working for the rights for all. But we have the journalists and the lawyers. They are special entities, but they go all to the commissioner. It's for me, it's so pleasant that he does not forget about anybody, and it's astonishing how much resources he needs. But thank you, and I would like to give the floor to Ganna Krasnostupa, Director of Department of the Strategic Communication and Promotion of Ukrainian Culture of the Ministry of Culture of Ukraine. So we spoke about the general entities, and now these are the special entities: media, journalists, and now these are the words which had to arrive today: Telegram channels, communication, disinformation, communication between society and journalists, where we can protect the journalist who is the investigator, who uses the personal data, and keep in the paradigm of ethic journalism, to use the data that went into the common space, but not the fruit of a poisonous tree that fell into the medium illegally. Where are the limits for the journalists? Thank you. Thank you. And first of all, protection of personal data and protection of any rights, they on three whales. One of them is the legislation, and Lilia is the best, one of the best experts on personal data protection expert, and she explained how GDPR is implemented. I would like to thank Julia for recommendations that were developed. So we spread them in the military administration with very human language, a very in compact way. So recommendation about GDPR, how to spread the information, and an important role is with educational campaign. So now for the journalists and for the publication, don't put your photos, don't spread your information. It's about regular citizens and for official functionaries. First of all, we should know about our own rights. Protect yourself, protect your own information, because the journalists, when they have the activities, they use the open sources. If the person spread his or her information, so they can make the reference about this information. So what we do in Ukraine, we created a coordination committee, and to protect the journalists, we implemented the free legal assistance. So what we have three key partners: National Association of Journalists, and they have a key partner, ABC Legal Services. Since 2006, they provide free legal consultations, and on the website and in the association, we have the form that can be filled in electronically, and there is a consultation how to protect personal data, how to be sure that you do not breach anything, and the lawyers they provide you this assistance. So the second is the Institute of Information. We have the Google form and the electronic address, and it's important. They also they read materials before public disclosure. So we not all of us know that media they don't have legal services, and it's very big resource to get legal free assistance. A third partner is the platform for protection of human rights. So it's a key turnkey solution. So they prepare documents for representation in the courts, in the European Court of Human Rights. So these are on the websites of our partners. Anybody can contact them, and we as a ministry, as a coordinator, we can spread it so that the military administration and the district administrations would know where to contact. But I would like to also to underline that Lilia showed as examples today is every case is individual. So we are on the verge. So personal data, access to personal data, public interest, especially about the official about salary, members of the supervisory board, and also managers of state companies. And if it is said in the law that information should be disclosed, there is no way to refer to personal data. So, but somebody can violate. So they ask people ask the ministry, and very often a regular citizen from Institute of Civil Society, we provide such explanations. I can provide for the office, but there are mechanisms of free legal assistance, and the journalists have the right if the important if we protect them. So why? To register a medium in Ukraine, it's easy. To become a journalist, it's easier. And when we registered our medium, we have less requirements. So just a blogger who got registered. So we needed to keep it to the legislation. So when we spread information, we can use any sources. So if the person spreads, it's on the verge. So everyone uses artificial intelligence. Whatever information we load into artificial intelligence, no matter which it is. So, for example, how to find information about the person? Not always, but for some examples, it could be Gemini, ChatGPT. Sometimes they don't want to accept them, but we can ask for 3 times the question, and if the person for some formulations, for some translations, and he or she uploaded the information about himself or herself, the person is there, and anybody can find this information if the question is correctly put. So to protect your own information, it's our own task of the citizens. And journalists can get legal assistance, because a journalist should not know every law. So there are specialized services for that, and please ask the specialized services for this. Thank you, Hanna. And so key words are announced today, and my panelists, they are speaking about the key phrases that shows the logics of our today's panel. So really, the importance of the public information and the purity of this disclosure has enormous importance in protection of personal data, and I refer to them always, and the colleagues refer to them in the explanations and the conclusions.
Наступного панелю.
And over to the next panel discussion participant. Actually, like all the panelists today, I would love to spend more time talking to each of you, but we will now talk about an important aspect of personal data protection in the current world, which is digitalization. As I work with international partners, I have heard from them oftentimes that the GPR is the enemy of digitalization because it slows down the digitalization. The artificial intelligence could do everything instead of us, but we cannot disclose many things to artificial intelligence, and many European countries really limit to a large extent the digitalization due to the risks of personal data leakages and Ukrainians started getting certain important messages through ordinary postal service. And the authorities consider that it means more protection. And I would like to ask this question to Yuri Tura, Deputy Head of the Directorate of Electronic Registers and Data of the Ministry of Digital Transformation of Ukraine. The digital transformation, digital innovations, and personal data protection. I think there are only challenges that you face. So what's your take on that? How does the Ministry of Digital Transformation find the possibilities to interact with society, conveying important information to it? Please. Thank you. Greetings to all dear participants. Of course, there are a lot of challenges. I will try to focus on some key elements of our vision in the context of European integration, since we have this discussion about the Ukrainian readiness to European integration. The Ministry of Digital Transformation is responsible for a huge package of European integration regulatory acts related to personal data, responsible for the alignment of Ukrainian legislation with the European one, and everything is related to Data Governance Act, Single Digital Gateway, and a number of other acts related to either exchange of data or processing of data. And of course, all of them refer to a certain extent to GDPR. And so the GDPR is the foundation of our European integration in the area of data. We won't be able to officially build all the other floors of this building, the trans-border digital services, etc. It will be impossible without the foundation of the aligned GDPR. So the stance of the Ministry of Digital Transformation is simple. We need to have a clear framework in this area as soon as possible, and I hope that we are on the same page about that. Any delays also cause a delay in European integration. The GDPR as the foundation is something we try to build our activities on, and we need to think about the next realistic steps we will be able to take before we become an EU member state. It will make available the trans-border digital services for us, and I would like our digital interaction between individuals and the public to be applied to different areas in Ukraine and replicated in the EU. Another important aspect, personal data do not exist in the vacuum. If for a second we leave the context of European integration and just think about our national context, in your opinion, what's the number of references to the law of Ukraine on information systems? Zero. And vice versa, the law on personal data protection contains no references to the law on digital services. So it says many things. It's something we have to address in some way, and the ministry starts acting. And my position is deputy head of the Directorate of Electronic Registers and Data. Before that, it was just a Directorate of Electronic Registers. And now this structural unit includes the subunits of the ministry dealing with the data to build the competence in one place and to have harmonized activity when it comes to open data, personal data. Everything is now in one single unit, and our goal is to have a unique strategy, a harmonized one, as to how we work with data. That's about the long-term perspective. It has to be applied to the totality of Ukrainian legislation, and it would be good if there are references between different regulatory acts and if everything is well structured. And the last point about artificial intelligence, everyone has mentioned, the AI is a top priority of the ministry. We have been actively implementing AI in the public area, and we found a way. Actually, the colleagues of other units, the ministry in general, found a way to avoid AI accessing personal data. And we absolutely need to think about AI. In this context, we really welcome such initiatives as European Digital Omnibus, which just confirms that there are many acts in the EU in particular. So we've been talking about the national context, but the European context is more or less the same. There are a lot of acts and restrictions and requirements. And talking about business, it causes some fears as to competitiveness of European business comparing to the countries with more with easier legislation in this area, but we support this initiative. We talked about the balance between openness and human rights protection. It's the balance between human rights and innovations, certain technological advances. And in the ministry, we are currently thinking about the balance between openness and protection of data of the defense enterprises, defense and industrial complex enterprises. And we've talked about data in this context. In our case, information about the place of residence of an individual is probably one of the most valuable personal data that can exist. At the same time, our register is considered as an open document. Basically, anyone can find out the place of residence of any individual. And of course, it allows to find these whether these individuals have any kind of ownership, property, etc. So there are a lot of challenges, and we have to look for the balance in this area. That's what we are going to work on. Thank you, Yuri. Especially thank you for underlining that the fragmentation of legislation is a drawback. That's something we legal professionals keep emphasizing. Certain things that have to be cross-cutting in this legal framework at the European level and Ukrainian level. Otherwise, we have regulations that do not correlate between themselves, and some people who do not have legal background might be confused. I have one more panelist who is mentioned here on the agenda as a senior lawyer of the Digital Security Laboratory, but I am always happy to pass the floor to Ms. Avdeeva Tatiana. She is not only a senior legal professional of the lab, she is an activist who took part in the development of the Framework Convention on Human Rights, and I was happy to follow the activities of this group. Could you please share some insights about artificial intelligence and personal data? What's this view of the Europe, and what's our view of that? That's the question which requires a few hour answer. When we talk about new technologies, and not only the AI, we talk about the infrastructure. First of all, whether we have a proper infrastructure to ensure all the protection mechanisms in the context of the use of these technologies in any sector, whether it's activities of media, personal data, or public services, and what government does. So basically, every state has to develop such an infrastructure. And in my subjective opinion, the convention could be even better. Unfortunately, as everywhere, it was a matter of political compromise. I don't really like this phrase, but unfortunately it's true. What's important about the convention is that it offered a great conceptual tool entitled Assessment of Technology's Impact on Human Rights. The state, the public sector, and all public institutions have to make this assessment at any time. And it's a good step because it sets a framework for certain public obligations. Actually, Ukraine has signed the Framework Convention in May 2025, so we at least have to respect the goal and main guarantees of this convention, and after it is ratified, we will also have to conduct the assessment in the public area. The three key points I wanted to raise is first, what do we deal with in the context of AI? Then, what are the consequences in the context of European integration, and what should be the public landscape in this area? I totally agree that big Ukrainian actors are already implementing DGPR. We have a different issue. We have startups who try to look for their niche or area of engagement. It's hard to compete with the new Post or Rosetka service. So the startups are looking for something of their own. But how are personal data used in these new areas? Well, in Ukraine is often transformed into so-called testing field or a lab to test new startups because we have weak current regulatory acts. So basically, you can get a sanction in the amount of 800 hryvnias if some personal data was used improperly without guarantees. And who will apply it will be just a payment for a violation. Our infrastructure is not adapted enough to be able to spread the culture of personal data protection, and it's the first reason why we need the GDPR and why it has to be properly implemented. Second point is something which really bothers me as a human rights activist. Unfortunately, a lot of regulatory acts are considered in a vacuum. What am I talking about? Our law on personal data, which is equal to GDPR in EU, refers to many other acts, for example, the Civil Code. I personally am really worried that during public discussions we often hear that personal data is something separate and we have the right to privacy in our civil code. Unfortunately, it doesn't work like that. We have to align all of our national laws between one another, and it will help us to avoid the conflicts and develop this infrastructure. Lilia mentioned that our court practice is chaotic. I remember internet being viewed as media. Our courts do not know how to use the terminology in the area of big tech, and it's a huge issue. To avoid it, we have to clearly use clear phrases in our legislations because like they do it in the European Union, there is a Court of Justice of the EU which, in case if the national courts have some gaps, issue judgments and interpret these texts if the rights are violated, the rights that are provided for by the European Charter. So they have the highest body which helps to consolidate the EU case law. We have to be more precise in our phrasing of legislation, and not only that, we need to have adequate mechanisms to apply this legislation. Talking about the personal data protection and technologies, we often hear the abbreviation big tech. Big Western companies and other companies use technologies from across the whole world who are outside of Ukrainian jurisdiction. And here's the problem. If we draft a perfect law on personal data protection, which another act on artificial intelligence, another act on data management, etc., how do we ensure the implementation of these acts in the territory of Ukraine? And the big tech, we cannot guarantee that the big tech will apply these acts. For example, how will OpenAI or X or Grok respond to these novelties? Are we ready to apply harsh sanctions to these big tech companies? I mean, if there are judgments about sanctions, but the companies do not pay these stamps, what do we do? It's a difficult discussion. I'm not ready to give a clear answer, but it's about the balance, and we will have to talk about it when we design something similar to the Digital Services Act. Actually, the most difficult thing is how we implement the European regulatory acts for them to really work in Ukraine. In addition to all of my positions, I also am a member of a national LLM development working group, and one of the issues we face is lack of infrastructure and institutional mechanisms in the area of data management in general, not only in the context of personal data. When the state initiates any projects, it doesn't know what direction to take. We have a lot of great qualified lawyers, and we we have to think about whether we can take the state databases to develop the national LLM. On the other hand, the requests to this LLM will be able to phrased by any user, so the prompt engineering of the highest level might lead to such a consequence as leakage of personal data.
And actually, we don't have a very precise regulation how to do with this data, how to protect the copyright objects. And a huge problem, because people say now, for example, disclosure of academic works can be cited only from the educational and scientific works. So clearly the national model is not for this, but it could be cool if we would train the LLM with last scientific works. So when we face the practical issue, we don't know what to do. We say, oops, and myself as a representative of civil society, we go integrating into Europe. But on the other side, we have lots of the technologies, for example, GDPR is not used, but we use a clear view, and CCTV is not used, is not regulated, is used by the local communal companies, by chains of supermarkets. What do we do with such systems? Because we need only to develop the law, but we need that the practice would correspond to these standards. And now we come to the question, what can we do with the situation now? So on one hand, we should close lots of systems, and the projects in the public sector for 100%, we will need to close some project and even readjust them so that they would correspond to the standards privacy by design. So it's a red line that the forbidden systems, they collect data. We will say clear view goodbye, but how to do it? We will need to do the audit. We'll spend lots of hours and time for such things, and so we need to plan this in advance. Otherwise, we will have the collision with European standards about European requests, and so it's very bad because it will finish with the religion of the European Union, because we will breach the regulations, because the regulations are the direct implementation documents. So if we would do in a sneaky way, so just to try to navigate and to do it in a certain way that adjust with our laws, but we will get some sanctions. So these documents, these standards should become typical. So what we do according to the European international conventions should go into the normal life of Ukraine, but it will breach the normal life of a person. So also, and so people are protected in the European Union, and they are protected by the convention. But what will be with the landscape? So when we say it is not only by the GDPR, when Yuri was saying it's they act about the artificial intelligence, and the number of these acts, it's huge as an Excel table, and now even we see that 114 acts are being developed, and Lilia made a big map already. So we see how huge the work it is, and we need to plan what is our priority and what are the fundamental things, how to harmonize them. And at the end of this whole, we have Igor, so he likes this phrase about a spherical horse in a vacuum. So this data should not be looked at as a spherical horse in a vacuum. So we need to understand them as a system, and we need a regulatory institution also, because the laws they are laws, but how to implement them in a proper way, how to solve the collision if it appears, how to adapt the norms of regular character to new cases and to evolution of artificial intellect that takes place, and the legislation is lags behind. It's very important task. So we should understand that the institution should be independent. We should have the mechanism of application, and the institution should be capable to communicate with other regulators inside Ukraine, to have so to say capacities, to have experts, to have resources, financial, human resources, to be capable to communicate with European institutions. Even before Ukraine enters the EU, we should harmonize the practical approaches. Why? Because afterwards, everything will fall on the head what Europeans are facing already now. So to avoid this, we need to speak in advance, and this is task number one, to create the structure that notwithstanding the date of an entrance of EU, we will be capable to have the possibility to react to all these threats from the side of Russia, and from also internal situations. When we speak about the investigation of journalists that are always balancing the interests, when we speak about companies, they use personal data, and we should take into account this today and think what we should do. And I would say that Ukraine has all resources and possibilities to become a very cool example. We have a big number of modern technologies, and we have a big number of experts that face situations that European would never see until now, and not only face, but they find solutions, and these are the things that we should project to international audiences, and we should share, and we should continue with this. So I stop here and give the floor to you. Thank you very much. And really, I was thinking why in this very difficult scheme not to lose our biggest advantage. That is to know how to react fast to challenges, not to be afraid to use new technologies and new solutions. That's where Ukrainians are perfect, and innovation and competitiveness and using of technologies. What to say to Europeans? Sometimes they do not know themselves. And for example, when I read the new approach to management of data, let's say the data altruism, and I think so you also make experiments, not only us. Thank you that you put us back to this initial element of this panel. So the institutional framework, it's not only be to enter EU, but the background to survive in this difficult and bit cruel world where we are now. We cannot select of anything else. So thank you very much. I heard the opinions I wanted to hear today, and I cannot breach your right to the coffee. And at least I would say that at the end of this event, we planned a very good question and answer session. So prepare your questions, and you will torture our experts once again. So please have a nice coffee and come back. Thank you very
So I'm inviting to the stage the online participant Людмила Опришко. Людмила Pankratova will be with us here, and Vladislava Nishchenko and Lina Dashvar, please join us as well. We lost our panelists somewhere. Right, I can see Vladislav. So please take your seat. And we will resume with our second panel discussion, which is also an interesting one because the challenges of the wartime for the media environment, the practical challenges are not only difficult but extremely difficult.
And I'm Igor Skoladai. I'm a deputy director of the agency. And it was a deja vu to look at Wojciech Wewerowski, because I remember when Mr. Wewerowski came to Ukraine and he was explaining how it was working, the system of data protection, personal data protection, and greetings, I see you are with us. And actually, one of the first challenges that happened in our field was 2022. And it was the challenge of Geneva Convention number 3. Geneva Convention number 3 was written, and Tatiana Deva was remembering spherical horse in vacuum, and it was the impression that some documents were developed never gain position, and could not nobody could imagine that the state that sends the military to the war, people were saying it's not for us. And the first challenge was for the journalists what to do, and not to speak about war prisoners. It's impossible. So we needed to show about them, and we needed to take them back. But on the other side, there is a position of the convention, because that says that any disclosure in on TV and radio, it's impossible according to the convention. So it's this is the example how many problems the war opened. And I don't know if Victoria Rumnik will join us, because I wanted to start with her, but she was telling us that she is coming from the US to Poland today, or maybe she will switch on. I don't know now, but now I would like to start with express questions to you. For you, since 2014 or 2022 became the first challenge related to personal data and journalism, what triggered you to understand that we have really problems here? So let's start in a circle. Ludmila, please, just a short impression. What was the problem? Actually, the war sharpened the problems that existed already. In fact, the conflict between protection of personal data and disclosure in the media, this conflict existed always, but the war pointed out the problem points which we didn't think about, and actually so we have the points where the missiles attack, and the media had to show the event and do their work, but on the other side we had to do it very cautiously, very modestly, not to breach the interest of the state. Maybe I will stop more on this, and I will give the possibility to the colleagues to add something. So thank you. And And good afternoon, colleagues. For me, in 2014, the challenges were related to the laws that happily they didn't happen. These were the laws of the 16th of January. And finally, I just remarked that the showing of missile attacks and we had to explain to the journalists why should not we show these missile attacks and explain to foreign journalists. And when the Ukrainian journalists were saying CNN is showing it in live and we cannot do it, and actually the war prisoners, we explained to ourselves in which way and how we could do it, because technologies changed and exchange of information, and how this convention, you remembered, Igor, these were the challenges, and today they're a bit of more, as the challenges they are different, but what I noticed, these were from the beginning of the large scale and for me, speaking about the experience since 2019, I started as a representative of the commissioner in the Dnipropetrovsk region, and speaking about the main challenges and those created by the full-scale invasion, and these were the users and the owners of the information, how they wanted to camouflage them as personal data. The access to public information and open data was limited. Dnipropetrovsk region at Dnipro city, you can remember lots of things about it. So think about this and how at the time we fought actually to make the public information public and not to be hidden behind some personal data. At that moment, we called the salary as personal data, and now we understand that we created a revolutionary move, and even to remember such ideas, it's even funny. So hello to all, and I'm Alina. I'm a civil activist for protection of children's rights. So I encountered this situation in 2014 when we started to evacuate the children from Lugansk internats, and then we, for the first time, we faced the private information about the children, and it was very difficult to evacuate children to the continent. And that was the first encounter of information. So thank you. And so it was big touches. I think actually you had more of them. Unfortunately, Victoria didn't connect to us. Maybe she will be able not. But the fact that checking, it's a difficult part of journalism, and so what I hear now from the teachers of journalism is that the new journalist generation, they're fully different in the consumption of information and spreading of information. And we understand that the children from that generation, they start to use YouTube even before they start to talk, and TikTok generation. It's interesting for me if future journalists will understand about the personal data and how we will work with the whole generation of people to explain that this big bases of data, how they can be personal in this new big world. So coming back to our speakers, in the previous panel, we remembered about this patch legislation, and my question to Ludmila Prishko, I know that you wanted to share with us with your impression about the balance between different norms, and this balance is on the verge of two laws, even bigger ones, the civil code and the copyright. the right to access to public information and public interest and protection of personal data. So please share with us. And the only thing, if we have the signal slowing down, so maybe we'll switch off the video, maybe the voice will be a bit slower, so we will go to audio mode. So what is your problem as you see it, and how to solve it? So thank you. So I was listening today attentively for the first panel, and because the changes in legislation that protect the media interest me a lot. Lots of interesting ideas and remarks on this sense. And I would like to remark that this fragmentation exists, and not only with the introduction of regulation of digital technologies. This fragmentation exists even on a more traditional level when we speak about regulation of the right of expression and the rights of protection of personal data. And so we pointed out that these rights they compete, but in fact actually they should reinforce each other. They don't have any hierarchy above each other, but actually in life it is not like it should be in the theory. And if we speak about new law on personal data, or draft law of personal data protection, which is in Parliament. Yes, it is a progressive draft law, but some norms that related to video filming, it could be combined with the legislation on media activities and legislation on speech and freedom. So, because there are some questions about the about taking of videos, because some norms of this law could not be fulfilled even by journalists, because they are a bit contradictory. I will not go into details because we don't have time, but I would say that there are changes in some quite basic laws, and there are registered changes in the civil code of Ukraine. Then there will be also changes. And so this fragmentation should be promoted for sure. And in the new personal data protection law, it is not defined clearly the journalist activity. So it is very narrowly specified. And so in this sense, in this aspect, we have something to work on. But all these changes that we should put into this developed law, I would not like that my words would be treated as that reduce the importance of this law about the personal data, but it's about only to make some changes and to make these norms balanced at this phase. And also we live in such very dynamic times that when digital world is changes actively, legislation is changing very fast. And we should understand that the journalists who disclose personal data, they sometimes become the victims of spreading of personal data. And now we speak about the strengthening of control over state agencies that collect data. They use them, and the leakage of personal data happen. For example, we can remember in the Medici case, when the detectives they pointed out some 10 files on very well-known journalists. So the information was gathered, and this information could not be gathered from other sources than the sources of law enforcement authorities. And the war, this is the control over personal data of all citizens, and it's important that the access to such personal data would be controlled for getting legal access to such and spreading of such data. And we should point out that the investigation bodies should keep that the secrecy, that at the same time we see the fact that the photos are disclosed about the intimate photos of Vitaly Shambunin, which is not acceptable now. And in this case, we should understand very fast and clear reaction to such facts to avoid them in future.
I would also like to add that currently our organization, the Platform for Human Rights, monitors the respect of these rights in Ukraine. And as we can see from the messages on media, journalists complain more and more because of coordinated campaigns when their personal data are spread or used for discreditation campaigns. Not so long ago, the Women in Media NGO informed that the Base 111 Telegram channel spreads personal data of the Ukrainian media professionals, and it has collected a lot of data about everyone, and they call these people traitors and propaganda agents, and we can look for ways not only to stop these activities but also to delete these bases from the internet. Olena Mudra informed that there is a coordinated and targeted campaign against her through the websites, Telegram channels, and for that, and all already available information is used, like photos, in order to discredit the journalist or organize a defamation campaign against her, because the photos were disseminated with inscriptions that she works for Russian officials, Russian institutions, etc. So the journalists themselves often become targets of such coordinated information campaigns. And it seems that this pressure will only become bigger. So we need to look for ways how to counter these coordinated campaigns. And it seems that the old methods become more and more irrelevant since most sources that spread discrediting data are anonymous. The only legal remedy is to establish the false nature of this information. But what should happen next? How to make someone spread the message that this information is false, and even the collection of information to apply to the court to establish the fact of the false nature of information is something which takes a lot of efforts, and it takes a lot of time, money, and efforts. So there is this question of efficiency of protection, but are there any other legal mechanisms, any other remedies? Most probably not, but it's a huge challenge, especially in the context when it is easy to select a victim. It can be anyone active on media, especially, and there might be pressure exercised against these people. So we need to do a lot to find efficient um, mechanisms for counteraction, and obviously we will have to um, gather the efforts not only of the media community but also of those who have some impact on the digital environment. Thank you, Lyudmila. I will give some more context about Olena Mudra because she is a journalist investigating illegal destructions of forests in Transcarpathia region, and it was related to to some energy facilities installation, and there have been deep fakes generated in relation to Olena Mudra, and her son was involved in it. So there was a deep fake created based on the fact that her son is allegedly an LGBT community representative, and it was a quite a good deep fake of a good quality. And for example, a video from Suspilne studio, public broadcaster studio, was used for that. So it's not about the privacy of a specific journalist only, but also about her family members. And the biggest problem is that it was done using anonymous Facebook and Telegram channels, and we can try and say that it's a violation of privacy, but it's always quite a complicated discussion with the big tech because they always try to avoid everything related to the content, and to protect something on a big tech platform. You know, there is this old funny story about a university exam when students try to avoid answering specific questions. So it's something similar about the big tech companies. Then we have Lyudmila Pankratova. During the first panel discussion, we mentioned the checks that happen before we publish information. Actually, Lyudmila is involved in that, and I would like you to talk about the challenges of investigation journalists. What happened during the full-scale war? Spoiler, I know it will be something about the registers. Please tell us what are the biggest issues in your opinion in this area, and what are the gray areas that require at least professional discussion. Thank you, Igor. Yes, I represent the Institute for Development of Regional Press. It's another organization which provides free assistance to journalists, and we work closely with investigation journalists to check information before they publish certain information to detect any mistakes. And it's a very difficult job in the sense that you understand what rights might be violated or are already violated just based on your experience, and you have to do everything to prevent journalists from publishing this information. And last summer, together with the Journalist Ethics Commission, we developed ethical standards for investigation journalists, and we focused on how to work with personal data of children in particular, with different photos and videos. As we collect information, many depends on how journalists collect information. We are used to see a lot of information in open sources, and it's mostly a legal way to get information when we use the open sources. As to the problems investigation journalists face, actually the legislation has changed, and since the start of the full-scale war in 2022, Ukraine made a derogation from the European Convention, including Article 10, but there have been no specific like regulatory acts. Why is it important? Because if there is a derogation from the convention, the state has to set very clear framework when this derogation is being done. And if we take the law on access to public information, it hasn't changed, but the laws, journalists experienced some limitations in terms of information access in some regions. You can only get access to the regional council if you are accredited by the Ministry of Defense. No one explained why it was necessary in Khmelnytsky or Chernivtsi, which are the western regions, but these attempts to restrict the access to regional council meetings happened. As to the journalists, they do work with the open data like registers, and it's a legal way to get information that we tell about. Why do you need to get access to get data from some suspicious sources if you can get it from the open registers? In 2025, there was a law adopted, 11.533, and the access to registers was complicated, and from that time on, the journalists had to spend more resources and time to get information from the registers. They have to contact notary agencies. Going back to the derogations from the Article 10, we can ask a question: what are the grounds to limit the access? The answer is simple: to protect national security. And this ground is justified in our conditions. Yes, protection of national security is very reasonable, and the access to place of residence is limited, as well as the location of defense complex facilities, but it works a little bit differently. For example, in the end of last year, the journalist we've already mentioned, Olena Mudra, who investigates the topic of environmental violations in Transcarpathia regions. She works with wind energy facilities. So she found that certain bodies register defense complex facilities in Transcarpathia, and she publishes only open access data. A question: is it an indication to the location of defense facilities? She hasn't violated any laws, but if the legislator introduces certain limitations, it has to understand whether they are efficient in their totality. Maybe some things have to be restricted, others not. So some things may simplify the lives of those involved in corruption, and so we have to think about that as well. On the one hand, I probably should protect, defend journalists, saying that restriction of access to registers is bad. On the other hand, the state has to understand clearly what restrictions apply to certain things. So there has to be a certain separation. As to personal data protection, and we've already mentioned the Geneva Convention, including prisoners of war and IDPs. The journalists have studied how to reach the balance, in my opinion, and I would like to mention one investigation which had a quick impact. It was the investigation published in the end of last year by the Следство Info editorial office. It was about the children evacuated to Turkey, and it's about two girls, the minors who got pregnant and gave birth to children. And I think that it was hard to reach this balance between conveying information and avoiding the breach of privacy. We can see the faces of these children in the video. They also state their names. Another case of evacuated children. They were evacuated from Zaporizhia orphanage to Poland, and the head of that institution basically was putting psychological pressure on children, and she was quite aggressive towards these children. And in this case, this investigation made by Radio Svoboda or Liberty is quite sensitive. The state has to develop an infrastructure to protect those who cannot protect themselves. It's obvious, and it has to also apply to personal data protection. And it seems to me that they found a balance between the personal data coverage, because not every child was shown, and such method as drawing was applied. So there were drawings of children that made it impossible to recognize the children. When we work with journalists, we try to make them understand that personal data acquired from to investigate corruption schemes very often may be taken from the security cameras, and we might see some vehicles moving with their license plates. And we also teach journalists how to use this information in a way that legislation is not violated. But I support all the speakers who took the floor before me, and I support the fact that we have to include into the legislation the personal data protection on the one hand, and the balance with the public access to information.
Also, I would like to say that there was an attempt which was stopped of influence of some limitation of journalist investigation because the draft law was stopped 1042, which envisaged the increasing of the punishment for unsanctioned and selling of information that is processed in public registers. So this is the pressure on those who open and discover the situation. But if you look at the legislation, on one side we should assure the rights of those who investigate, but not like it is now in the criminal code, how to become the investigator, and this situation was written in the way that could be used or applied to those who gave the information to the journalists and to the journalists themselves, and this was the danger, because the journalists could feel the pressure on their work. So I see you took the microphone, and so we will see the questions and answer session. And I would like to come now to two speakers. You will present both of you. So this is the question of children, and Lilia touched a very interesting topic today, and I tried to put myself on the side of the journalist and the lawyer and protector of Ukrainians abroad, and member of the family. And I see that this is the case that inside me it creates the internal discussion. So in today's world, to find out something, it's quite easy. Even the journalists that do not show where there was a missile attack, to find something, it took me 15 minutes. For example, it was a Czech project. All these attacks, they are developed, they defined immediately. So the last attack on the left bank, so it was blurred, and for me it was enough to through the telephone and through Google. It was easy to find out. It was in the garage cooperative, and it's very difficult to find something today in today's world. And the other situation, if you are on the verge of consuming of information, and if you don't show the story, you are not free to do it. So it could work very much for us to get protection. So it touches the emotional feelings of the people, and then you understand that this hand would help to save the life of somebody, because people who saw the hand, they would pay money and give the donates to save somebody's life. So I do not envy the Office for Protection of the Children when you protect children. So maybe you would tell us the case that made you think a lot. And I know that you have the presentation. Please, our technical service, put it on the screen, and please present what you are working with the cases related to children during the full-scale invasion. Thank you for the question. And first of all, I would answer when answering on whose side I should be. Without compromise, I would say on the side of the child. I am Vladislav Nishchenko. I am heading the monitoring of the children's rights, and speaking today, whom we can related to the journalist community. Thanks a lot to the journalists who fight for the rights of the children. And second tool is how to protect children's rights without breaching the rights. And in 2025, Office of the Commission had more than 800 visits, and found out hundreds of violations of the rights of the children, and we saw 200 cases of violent behavior with children, and among them there were violence, physical and sexual, and placing children in the psychiatric institutions, breaching the procedure, and the cases with which I could work. Those cases where we were working with, we find the situations when they are not only crying, they cannot even come into the mind. And for sure, every such story could be a very good reason for opening the material, and it would get lots of likes and views. But unfortunately, we put as the main task when we find the breaches of the rights of the children. First of all, it's disclosing the crimes, finding the guilty and taking people to the responsibility, and also taking the attention to the problems which exist. And in this context, we should say that the public disclosure is a very powerful tool, but using this tool, the child can not always be the subject of the protection. And as a rule, in such cases, when we see some journalists, they wanted to protect the child, publishing his or her story and publishing the data that can identify the child. And we know the examples when the children can be bullied and they find new sufferings, moral and all, and suffering from other situations. So we should say that journalist investigation and journalist content can also breach the rights of the child and work for the enemy propaganda. I should also underline that without any speculation and without any breaches and twisting what I am speaking now, in no cases the Office of Commissioner hides the violations. The Office of Commissioner does not close the eyes on the violation of child's right and points out and the violation of such rights, and we show it in the report. We send it to the competent authorities. We ask the bodies of the police and the general prosecutor's office if we see such violations can happen, and we call the police at the scene when we find the violation of the child's right during the monitoring and when we find the tortures as well. But it's important to mentioned that during this period, almost 20 criminal cases were launched, were initiated as a reaction, and about 30 persons, they were under disciplinary sanctions and dismissal, and also the law enforcement officers who did not react, and they ignored the rights of the children. If maybe you know, when the minor boy asked us about the tortures in the psychiatric clinic, and the police came and they didn't take this his application for criminal situation, and when he asked us, and really we came and we saw the situation and the conditions, and the criminal case was initiated, and there were sanctions for the policemen for not acting. So when we speak about some violations and we do not present details, it does mean that we close our eyes and we don't work. And it's wanted to say that child's grief, it's not it cannot be a content, and a child's story cannot be evaluated through a number of likes. We should say that we have international legislation, and we were saying about international regulatory acts in the field of protection of personal data in Ukraine. It's important to point out that during the situations when we show the child, we should use the Convention for Protection of Child's Rights, and the Convention on the Child's Rights specifies, first of all, that at the first place we should have the best interest of the child, despite all the noise this material could create, and despite all the pluses of spreading this material, but very precisely the child should always stand on the first place, and then every child should have the right to privacy, not intrusion into his or her life, and the protection from violence, from all ways, forms of violence. And it's important when the child had the violence, physical violence, so asking the child, how was it, what did you feel, and give them public space for the person how she did this violence, how this child was violated. It gives the moral suffering to the child, because we speak now about re-traumatization, and this is under the category of protection of the rights of the child from violence. And another point is restoring the dignity of the child when the child suffered from violence. And the key principle, summing up, if to say so, it is ignored very often in practice, and even publicly important information could not be spread through very big violations of the child's rights. And it's important to mention that the Convention of Child's Rights is reflected in Legislative Act of Ukraine. So we have the law on media. There is about violations and using information against the child's right, and the law on media. We have the code of journalist ethics, and there is a issue of how this content and editorial policy about using of information on the child, and how should it be taken into account. And so speaking on about these points that we speak about today, Ludmila, please, I'm very thankful to you, because this topic is very close to us, and you used the two topics that we will speak today more in detail. Is a story about evacuation of children to Poland and to Turkey, and just before the materials that we will spread today and present, we use the test and the filter when we can use this material. And the first thing is if this information can have the public importance. We should understand here if this is a systematic problem. If we speak about the violation of the children's rights, the not doing of the official authorities, if there is a threat to the life of the children. So you were speaking about the children in Turkey, and these children were already for 1 year in the evacuation at the moment of the publication of this material, and we should understand the public importance of this material and relevance, how this material can harm the child. And so the question is, should we achieve the result without disclosing the personal data of the child? And should we state, first of all, what is our goal? If our goal to get coverage and likes and good statistics, it's for sure it's not about the rights of the child and protection of the child's rights. If our goal is social justice and social protection, criminal proceedings, protection of the child's rights, we should think what were the measures taken before the public disclosure. Should we ask the Office of Public Prosecutor if this criminal case was closed, and for example, and maybe it was not performed correctly? Should we disclose all the elements of the violence on the child can we make it anonymous without to launch again this criminal case? Maybe when we ask the Office of a Public Prosecutor and saying that there were no violence, and it should not be so much violence, and the body of a pre-trial investigation did everything. So I agree that the criminal case, it's the extreme measure. So we cannot do anything else when the lawyer asked the final instance, and we, as an office of the commissioner, as the last case, you remember in the last year, in March, there was the material that in some institution in Mykolaiv, the minor children were tied up with ropes just to improve access for some services for themselves. So children were attached and tied up to the wheelchairs, and the child could not take out the probe. The arms were tied, so the child could not touch the probe. And so we asked the police, and we made the press release. It was spread very much, but we continue to keep the control. But the commissioner's office cannot influence the criminal investigation. But when we asked the bodies of a pretrial investigation, we found out that this criminal case was closed as if there were no crime. So the children were tied up they were treated inappropriately, so and the case was closed, and so the children could be tied. And so, of course, we asked the Office of Public Prosecutor, and the case was relaunched, and we hope for the full and complex investigation of this case, and accordingly, and the changes in the system. But if we speak about this list of the cases, we should, before any publication, should ask ourselves these questions. And the last thing, if the advantage outweighs the harm, we should be conscientious that it can come to re-traumatization of the child, and traumatization, bullying, repeated violence, and increase of the people, number of people who know about this, and increase of the outcomes afterwards. So if the child agrees to spread the information today, but when the child does not want to spread it in the future, but this information is already circulating, and we cannot take it out and delete. So we should understand also that who would support this child if anything goes not in the way as it was planned, and when we didn't weigh the advantage and the harm. Who can protect the child? Who can help this child when he or she becomes an adult? Lots of questions, and to open the question of the outcomes, I would like to give the floor to my colleague.
Thank you. My name is Lina. I am a public activist in the NGO scene with the heart, and I would like to talk about the risks for the child when we publish personal data of a child. The first risk is the secondary traumatization. It's clear if we ask the child the same question several times: how was you? How were you treated? Etc. The child might find themselves in the same state, emotional, and to be triggered. The second risk is the loss of privacy and self-control. I would like to talk about it more. I am the graduate of Children's Home, and we had a lot of journalists and volunteers, and I'm 36, and my photos as a child are still on the internet, and when I was a student, unfortunately, it was an obstacle for me during my university times, because my peers were saying, "Oh, you are from the orphanage, we will not talk to you." And so when you do your materials, when you post your materials, you should blur the faces of children. You should not tell the age of the children, so that in future the child is able to live calmly. The fourth risk is long-term digital trace, because people grow but their childhood stories remain on the internet, and that is going to shape how they are treated. And another risk is the security risk. I work with the families that found themselves in difficult life circumstances, or the ones with the children with disability. And we had a case when we moved the child to a village and in western Ukraine, and it became publicly known that the mother had alcohol abuse problem, and we had to move the child to a different village because the locals were keeping distance from that mother, because they found this information on a public page. So you can see the screenshots, but we blurred everything. You can see how information is presented about the children with hearing impairments, and all the information about children was communicated by the journalists with addresses, and the journalists even indicated where the children were studying. Just imagine how it is for the children to go back to school. And of course, it is also indicated that the mother is the cleaner, and it was mentioned here in a very disrespectful way. And you can see how the child with AVC was almost evicted, and my point is that the diagnosis should not be underscored, especially without the permission of parents, and the parents had to look for another school for the child. Another slide, you can see the same headlines for you to understand that the headlines might be harmful for the children. And the two cases that were already mentioned, how the information is presented about the evacuated children to the Turkey. So everything is blurred. No one knows what children we are talking about, so there is no threat for these children. Quite often when children want to disclose something to the journalists or the guests, they go ahead, they do speak openly, but then the journalists or bloggers indicate every detail on their social media to help the child, or to get these posts shared by as many people as possible. So they tell every detail about the children in orphanages or difficult life circumstances, but they always should think about how to avoid excessive harm for the children. Sometimes journalists indicate the name and the age of children. What do teachers do after that? They bully emotionally. They can ask older children to put this pressure, and they do it in their own way. Next slide. So now you can see what was violated. Confidentiality was violated, the consequences of posts were not assessed, the child's best interests were overlooked, and the public outcry was made a priority, but the children, or even more so teenagers, bear the consequences, and we can see that the harm to the children is bigger than the use. And when children in the orphanages find out that their information is already on the internet, they are afraid of teachers, new psychologists, because they will they might be punished with food or isolation. So you should always remember about confidentiality and how you present information. It's about the children evacuated to Turkey. It's important in the context of war. Unfortunately, we live in the context of information propaganda during the full-scale war. And what does Russian Federation do based on what the of all the cases about children? Russia starts manipulating and saying that in Ukraine they cannot take care of their own children, so we will now give them back their children, will not return them from Russia, and it negatively affects the activities of those who bring children back to Ukraine. It's important to understand in this context how we present information about violations so that it's not used by Russian media later. And here you can see the screenshots of how Russia uses our investigations about children. And you can see that even the First Lady is mentioned, the children from the Turkey are mentioned by Russia. And here you can see what we can do to secure the children. When we produce different materials, we have to check the information and check whether we have permission of parents or official caregivers. Then we have to avoid such labels as victim of violence, survivors. We do not make children recall what happened to them. We do not ask them repetitive questions. Tell me one more time, be more specific. We should avoid that. Do not ask questions that make children describe those who exercised violence against them. Check that the faces are blurred. Absolutely, you should absolutely do that. If possible, blur the whole body of the child to secure them. If possible, just draw the children. It's a great example how to secure the child. Also check whether there is medical diagnosis in your material. If the parents or the child do not give a specific diagnosis, you as journalists cannot indicate the diagnosis because these children have to live with it. There is visible and invisible disability, and probably a child or an adult with invisible disability doesn't want to talk about this diagnosis or condition. Next slide. And here you can see how you can avoid mentioning certain things. We've drafted a vocabulary. So we avoid calling orphans little one. We just say children without any transformation of these callings. We do not use any modified names. Referring to their past in the orphanages. We even avoid saying institutionalized child, and disabled children. Thank you for applying this correct naming. We say only children with disability, and we should say a child with disability or a child without disability instead of a healthy child. And here you can see the QR code. By scanning this QR code, you will find a vocabulary that you can use in your publications. Thank you. Thank you for your attention, dear colleagues. And finally, I would like to add that if you write materials about violation of children's rights, include such elements as how to detect a certain manifestation of violent treatment and what to do to protect yourself, what numbers to call, how to tell others about such violations. We have to add that children are not alone. There are NGOs and the Ombudsperson Office of Ukraine, which will protect children's rights. Thank you, colleagues. I would like to draw your attention to the recommendations you have in your leaflets, and there is one important element in particular, the point 8.1. The media have to take into account the level of maturity of a child. The lawyers often stress it as well. Even the permission from the parents is not 100% guarantee that the right can be that some information can be disclosed, because even parents cannot always know about the risks. So the lawyers of outlets have to be consulted, and please do not use the word mass media. Use the word media. And if Ludmila is still with us, we will thank her. Victoria couldn't join us, but we all know her, and we know that she does important work for Ukraine. Now we will ask the panelists to take their seats in the audience, and I will invite Tatiana and Julia for the final set of questions and answers. And I will ask quite a provocative question. What do you expect next? What are the risks that might not be so obvious, but that we should already think about? And maybe we need to think about some things in advance. In the area of personal data protection, yes, of course. Maybe the artificial intelligence, maybe deepfakes or something else. I'm really worried about the access to state registers data, and I have a very practical example. So we might think about the first aspect, which is protection of information as such, meaning prevention of leakages. It's one side that we work on together with the Office of the Commissioner. We try to communicate at the lowest level, at the level of village communities, that the whole procedure of collection, accumulation, storage, and processing of personal data, and also destruction of personal data, deletion of personal data, has to be clear and regulated, predictable, so that all the participants of the process know what they're doing. One of the things which made me sad in the beginning of the full-scale war were the basis of the personal data that were left in Kherson and that the occupiers got access to. There was a register of anti-terrorist operation. Participants or information about the children getting financial assistance from public authorities. When it was not in the hands of the occupiers, it was something ordinary, but after occupation, these registers were used to for the occupiers to seek revenge. When we came to Natalia, when we came to notary to after the death of my relative, we found out that they had access to the database that was open since 2014, but it was not communicated. Yes, it's a very old problem. It exists since the existence of the personal data, but it's just something that we do not pay sufficient attention to. Some bodies do not understand that we have to prevent leakages of personal data as soon as possible, and the lawyers who consider providing assistance to the families in need should not know what are the diagnoses of the children, for example. They just need to understand whether the local councils have the financial means to help the children who need it or not. They trust the workers of the social protection authorities, but the local councils members do not always undertake to not disclose personal data, so they do that. Excuse me, it's a very ordinary work not everyone wants to do that we're speaking about. And another thing which really bothers me is quite specific, but in European community, there are still ongoing discussions about the limits of personal data protection. We had this case Lily and I are referring to about the access to the register of beneficiaries and their personal data.
I will remind you the story in the anti-money laundering directive directive number 5. So it was the permission for the countries to publish a very small, very limited list of personal data with nationality and part of share in the business somewhere. So this is a micro part of information to identify. So we can understand that the owners of some hotel complexes in Croatia bought with stolen money, and they would not be happy to know about their personal data. And when the European countries they introduced this data, and even Ukraine, when was participating in the prevention of money achieved through illegal way. So and introduced also, but the European Union decided it is not good, and so 8 countries were receiving the decisions just to put it back. And nobody knows what to do. It's so loud, the noise there. So the countries they tried to come to reverse back and what to do with the journalists, and there is no mechanism to reverse. And the Transparency International they published how big the volume of destruction of the system is going on. So so the development of investigations against corruption, we are magnificent how the journalists are doing it here. Just I fully recognize. Please, I would like to comment. I have some fears, maybe, but people will support me. So the first case is using of artificial intelligence irresponsibly. As for now, many citizens are using artificial intelligence to finding the diagnosis. They introduce their personal data into ChatGPT and bots, and so this information we should understand that will be used against us in the future, and until we make a reform in the protection of data, personal data protection, and until we make changes in the legislation about artificial intelligence, I fear that our personal data will be under huge threat and the threat of leakage of data, and we don't know what will happen in future if the artificial intelligence is used irresponsibly. So this is first of my ideas, and second idea is irresponsible use not only of AI technologies and also not knowing the existing laws, actually the personal data protection law. I want to say that many citizens of Ukraine, they don't know what it is at all, because we are communicating as if in the same bulb, one bulb of journalists, the second bulb of lawyers, but actually we have communities in the Facebook, and sometimes we put pluses and ticks, and everyone is okay, everyone knows about personal data. Why should we know what it is, the personal data? But when we come down, when we go to the communities and talk to self-government bodies, when we talk to the mayors of villages, when they hear for the first time about personal data, about public information, looks like since 2011 we try to introduce and popularize the information about personal data protection, and make people aware about public information, what it could be as public information. Many citizens here, they don't know what it is. So I call for you, dear journalists, and please ask the Commissioner for Human Rights in the Verkhovna Rada of Ukraine. Please ask him about keeping the rights of the children, so that we together would break this wall of with educational work, and would bring these important issues in a very clear language to everyone, so that the people from not only from the school desk, but even from kindergarten, people would understand what is personal data, so the photos cannot be published in the media, and without using the accounts for children. The parents create accounts for them, and children, they make videos, they pump and download them into Instagram and other social media. And of course, they have a policy of privacy. Something is limited, but this digital trace will remain forever, and when the parents they are proud of the achievements of the children, it looks like it's okay, but some years later the child can be shy of this information. The child can not understand the heaviness of this tragedy. So I have three ways and three factors for use of personal data and use of, to say correctly, to have hygiene to use the personal data. It means keeping the hygiene of use of personal data. We should know about it, and we should know it since the kindergarten. And please, in the audience, do you have questions? Yes, if I come and you will present yourself. Thank you for this floor, Shevchenko Alexander, expert on protection of personal data. So I have not a question, but a small remark to the panelists. So first of all, the most important topic during the war, the media is the fourth pillar of public power and democracy in the society. And when we speak about personal data protection, first of all, the society should know about it and where we will find the balance between the right of the person to privacy and right of expression of views. So here we should understand and what to do, because do not harm is what is happening when we use the information, because especially during the war, sensitive information becomes hypersensitive. Stealing of children, the military, their families, when we can not only see it as dangerous, but for the family and for the health. So also the practice of European Court of for Human Rights. There were cases where these cases, for many times, they were very well fixed and established. What is public information, what is private information, where is the balance? And also, I would like to ask the media that this balance we need to use a bit of more time and just to find it. Also, because when it is done, we cannot bring it back. Thank you. Thank you. I am from media here, and the balance of ideas we will introduce. But anyway, I am very thankful for this discussion and the security of private personal data for the journalists and those about whom they write, and myself. And I'm Yanina. I'm the journalist of investigation Sledstvo Inform. I am the author of this material about children in Turkey, and I'm very thankful to the Commissioner's office, and so it would be very strange if the office of Commissioner would not act in the interest of the children, because it's for the public interest, and it's very logic. And we, as journalists, we try to find this balance. What we do is should be in the interest of the society, and we should envisage everything in the interest of the society. I would like to share how we try to keep this balance, and so we did this legal expertise of this investigation, and we found all these risks before the publication, and the children that were mentioned in the publication. One of them, she is already adult, and the other one, she is 17 years old. She signed the consent to give us the right for investigation. So we started with a psychologist. We came with a psychologist, and psychologists defined if this discussion would be relevant. And the first thing. The second, we mentioned a lot of other things about our investigation and the children, and whether it did harm to children. It's a good example. The example when the children received the support, which they didn't support after the monitoring in March of 24, when the Commissioner's office came there. So here I have the question to the Commissioner's office, because you were saying that you wanted to find the justice. What was the justice that was established after for these children after monitoring in March of 24? When we noticed as a journalist, when we communicated with the children and the details of evacuation, and no justice was established, and that's why we did this investigation to promote the justice by the authorities. And when this was established in Turkey, and one of the girls, she had the support, legal support, and she could return the child to herself. So this disclosure would not happen. It was not only about the likes, and the children, they received the support from private centers where they asked for support. And if we compare the results of the story with the results of the state authorities, so we did this investigation because we didn't see the result of the state or authorities. And as for the Putin, so every propaganda, Putin's propaganda, so any investigation could be used by Putin's propaganda. So let's not to do at all the investigations, because propaganda will use it. And for me, it's an argument that could cut any activity at all. So we did our journalist work, which was first of all about the questions to the state authorities, where we mentioned Olena Zelenska. Also, we blurred all the children, and besides the girls who allowed us and signed. And if the Commissioner's office asked questions to the private fund, who after the 1 year after the investigation published the faces of the girls and asking for money, and when these violations were discovered, did you do anything to stop them? And if the Commissioner's office says that we should not publish personal data, why the groups of deported children that deported were to Russia, that came back to Ukraine, where they are published with the office of the Commissioner? Why we have so many news with children who can become witnesses in the future, and when they are invited to meet delegations, and their faces are disclosed together with the Commissioner's office, does not it contradict to the requirements. And so if we take into account all this context, I don't say these recommendations are they bad, but we should take them into account. But in our example, we should have an example about this, whether we should adapt it to our story or and what we cannot. So in principle, it's all, and maybe you can have an answer. Thank you for your comment, and if you thank you for this answer. If Igor allows, the representatives of Department of the Public Policy, I will answer to your question about the faces of children that published in. And I visited a lot of situations of return of children. And then children they pass the interviews here, and they sign consent, and we cannot publish the photo if they have relatives on the occupied territories, and if they have parents. So it's not the last question, but the consent is signed. As for the Turkey, I will give the floor to Vladislav for comments. As for the consent, first of all, it's important to mention that not always really the consent is for the benefit of the child, and we should understand that today we have cases when during the monitoring visit we also see that the head of the institution of education and bringing is the legal representative of the child, and in the most cases they don't act in the interest of the children. They breach these rights, and they allow to breach these rights. And of course, if we speak about the consent, we should understand first of all the legal ground is there, but second, if this balance is respected, and of course in all our publication we should keep to all these requirements about the risks, and we work with international organizations, and every child receives the appropriate assistance. And today we are in the Center for Protection of Children's Rights, and we are in the point where the children come back from the occupation where they pass at the Center of Protection of Children's Rights, and they pass through multidisciplinary team. They work not only with psychologists, but with other specialists, and for complex integration of children into the communities. And if we speak about what we heard in the context of not providing support to children after the monitoring visit, it's important to point out that first of all, to keep the balance, and to keep the responsibility of the public servant to not to disclose what it should not be disclosed. I would say that this case of the keeping of children, incorrect keeping of children in Turkey was disclosed last year in the report of the commissioner, and it's an official document published by the Ombudsman, and it was said that the officers came to Turkey, and they had this visit, and they documented the access of children to all services, good conditions, access to education, to all other services. And so, as for other cases, I said that I was working in Dnipropetrovsk region, and where these people with children were returned. I met myself as the children who were coming from Turkey, and collected this information, and what the children were saying was horrible, and the data that children gave us. But looking at the documentation and published in the website Ministry of Social Policy, we saw the dissonance, how it could happen that official authorities were saying that everything is okay, but the children say the contrary, and that's why the commissioner, Mr. Lubinetz, took this decision, so that that together with international partners, with the Commissioner of Turkey and Ministry of Labor of Turkey, we did this visit and we documented these violations, and there is the communication with the Ombudsman, and the children were staying in the hotel. It's not the hotel as we can imagine a five-star hotel. It's for a hotel in for the staff, and the children were sleeping for 5 in together on the beds put together, and the communication about the girls who are coming back. So it's important why whether it was impossible to relaunch this criminal case, because as we know, the closing of criminal case and Slitsva Inform knew about this in March.
And the information was provided already in the course of investigation. As I said, we are not a pretrial investigation authority. There is a secret of criminal proceedings. We tried to provide as much information as possible with the reports, with USB drives, with everything we had. And I would like to point out that the situation was the following. We came with a monitoring visit. The team was drafting a report. The report was later sent to all the public authorities, and everything stopped. Then the Ombudsperson of Ukraine initiated a meeting with the Prime Minister. So the Prime Minister is someone coordinating the activities of the whole government. And basically, a meeting happened about the role of everybody, what has to be done so that we help these children. It was not voiced in the movie, but most of these children are now with their foster families when it was possible, and some children were received surgeries after the return. So after our monitoring visit, there was this surgery made, and currently this child has improved eyesight. There were cases when the state was not reacting, like one child was returned and received social service after the return. About the balance we mentioned today, if you reached out to us right after you became aware of violations, we would have reacted earlier, and you would be able to insert information about other cases when the rights of children were restored. You said that the Ombudsman office wouldn't comment on that. So we do not have any comments from the Office of the Commissioner because you refused. Secondly, talking about restoring justice, have you contacted the pregnant girls after you detected it? Because when we communicated with the girls, we found out that no one from this monitoring visit or investigation was curious about the fate of these girls after their return to Ukraine. You also say that you initiated meeting with the Prime Minister. So if such high-level meetings were initiated to reopen criminal proceedings, would it be enough if a journalist privately contacted Office of the Prosecutor General to reopen the proceedings? We did contact the OPG and asked for a comment, but they said no. all the public authorities we contacted refused to talk to us except for the Shostak Foundation, and you could see the comment, the interview. The desire to hide the story, to avoid it being published, but no one was guided by the best interest of the child. Everyone wanted to protect their reputation. I'm not talking about the Office of the Commissioner, but other structures. That's what happened, and that's why this investigation was so critical and unpleasant for the Office of the Commissioner, because no one wanted to react to our requests when we were doing this investigation. Well, I think we are further and further away from our main topic of today, today's discussion. I should comment as an expert of personal data protection. It seems like you violate something, why can't I violate something else? So it's not the level of discussion we would like to have in this room. First, we are all learning by doing. We always learn how to use the algorithms. If I told you in 2011, when I was head of a structural unit within the Service of Protection of Personal Data, started telling you about the balance, about the public interest and privacy, you will be surprised and wondering what I was talking about. So the fact that 16 years after the emergence of the law, speaking about what are the correct ways to implement it, it's a great achievement, and the media do a good job, and they do a lot according to the ethical standards. The disadvantage of your speech is that the Office of the Commissioner exercises parliamentary oversight, and you are mentioning the executive branch. I mostly support what you are saying, but the question is about how to do it correctly. And you could show that there were issues on both sides, but there is something to build our practice on, and there is room for discussion how to do it correctly, since we are moving towards the EU, and we have to act in a way so that we are not accused to be barbarians in this area. So I'm very grateful to you for this final discussion about how it was communicated by the Office of the Commissioner, but I can say that they did everything they could within the law on the Office of the Commissioner. And you were right to say that until it becomes too painful for someone specific, of course, the authorities will not deal with it. But it's mostly the mandate of the Ministry of Social Policy. I'm saying it as someone who dealing with this separation of powers for many years. So thank you for what you are saying and doing. And I would like to add the following. Yesterday, I was at a radio station, and it was a social experiment because I prepared a list of questions I would like the radio workers to ask me. And the questions were similar we discussed today. Instead, the host suggested to prepare his own questions. So I said, go ahead, but ask the questions a grassroots citizen would ask those who use social media, TikTok, etc. So the list of questions was, what is personal data? First question, for example. And when I posted on Facebook that I went to radio, the comment was, should we talk about that on radio? And but actually our reality is that half of Kyiv region listen to radio, and it requires additional information coverage. So I would ask media to really help with making this information more widely known. Otherwise, people won't be able to use this information, the consent and other things. Sorry, it was emotional, but I just have to put an end to this ping pong. And I would like to react about the respect of personal data protection principle. You know that there was a request about the HBO produced film Chernobyl. Actually, this film was very interesting for me because my foster parent was actually working at that time, and the interpretation was not correct from the historical point of view, but the court in this case adjudicated to pay $500,000 in compensation, and the applicant also asked to hide the personal data, the residence, namely the place of residence, and it's just to show that Western companies, foreign companies also have issues with that. And if we look at the area of personal data in Europe, maybe in our case it's a bit worse because we started dealing with it later, but in general there is room for improvement everywhere in Ukraine and abroad. So on that note, we will wrap up. Yeah, if there are questions. Yes, thank you, Anastasia, for the suggestion. First, I would like to thank for this very interesting discussion. Thank you. My name is Yulia. I am the assistant of the member of the Qualification and Disciplinary Commission of Prosecutors. We currently consider the proceedings related to the status of a person with disability. In your opinion, how should we maintain the balance between public interest and protection of the prosecutor who is the person with disability? If we depersonalize the whole medical record, it might be unclear what's the logic of assigning the status of person with disability. Thank you for the question. I will comment if the experts will would like to add something, they will be able to do so. So first, if you send a request to get personal data of the members of Qualification and Disciplinary Commission of Prosecutors, you have to answer to this request and provide this information. And you might provide the document, but with depersonalized details. To answer your specific question, of course, if someone asks for a medical certificate, you have to think about every separate case separately and to consult with the member of Qualification and Disciplinary Commission of Prosecutors. And we have to provide information as an answer to the request. As we heard from Lina when she was given advice about children, actually the same advice will be applicable to all the other citizens of Ukraine, every grassroots citizen. If you are asked whether people with disability are employed in your organization, of course you can confirm that there are prosecutors working who have the status of person with disability, but it's not permissible to specify what the diagnosis. We've developed recommendations for the media community, but I understand that we have to improve the recommendations, and maybe we should phrase it as recommendation for every citizen who decides to post this information, to make information publicly available. And we have the provisions related to the processing of personal data with the list of sensitive information that has to be disclosed to a very limited extent. And so you can find recommendations there. The owner of personal data is the High Qualification Commission of Prosecutors, and it has to take the decision whether to disclose information. If it was a law enforcement system, they would have to apply the Code of Criminal Procedure, and the investigator or a different responsible person within proceedings will have to allow the disclosure of the data. In your case, you will be the ones to decide and to find this balance, to decide how much information to make available to answer all the questions of the society. But by default, the less the better. The fewer facts, the better. Moreover, if you anonymize, depersonalize information, whatever you call it, it has to be irreversible. So you control what you emit, and you are fully responsible for that. You bear administrative, criminal liability. So here is the person who can give you the guidelines how to maintain this balance between public interest and personal data protection. If I may, I would like just to add 2 words. This is about the personal data protection, but also about the access to public information. I discussed this example from the Qualification and Disciplinary Commission of Prosecutors, with the independent expert from the whole Europe who oversee the respect of Trump's convention. And it's about the cases when personal data becomes publicly available. And when I started telling about this case, the international experts were horrified, because for them the situation when a state authority reflects on whether the public has to be aware of the health condition of public officials is something shocking. And I had to explain the context and the public interest. And here we go back to the matter of public interest. I tried to explain to international expert that even this kind of very sensitive personal information is subject to is something of public interest. And the information about the presence of workers with disability is one thing. The information about the number of such workers is a different thing. The information about who are those people, it's another thing. And then there is a matter of their diagnosis, then it might be the matter of their blood test results. And Lilia was right to say that it's personal responsibility of those in charge of access to personal information, personal data, and they have to take the decision according to the 3-pillar test. Another brief comment, we also talked to Norwegians about this thing. I want to protect the position of the commissioner. The colleagues were sharing that they tend to not provide this personal information, and this decision cannot be overturned by the court. Please consider that the Secretariat of the Commissioner is not an investigating body and not a court. They do not have the capacities, expert capacities, and legal capacities to conduct this assessment according to the three-pillar test. And the Norwegians think that not even the court can reassess, because only the public authority knows the whole context to take a decision. And there is also the European Court of Human Rights, but they really trust the decisions of the managers in every specific case. And the last phrase from me, I really liked this discussion between the Office of the Commissioner and Info journalist. And if we look at this discussion at the right angle, it's rather about cooperation. Look, the Office of the Commissioner didn't silence this case. To the contrary, we just have to understand that in every case there are limits to our mandate. The Secretariat of the Ombudsman did what it could, the media did what they could and deemed right, and there were other actors. We could ask them as well whether they did everything that was possible and correct and everything they had to do according to the law. But once again, I think there is more room for cooperation than for an argument in this case.
Thank you for this question, and thank you, dear community, that you visited today our conference, and I hope that the topic were very interesting. Once again I wanted to greet all our partners, all the international experts with international personal protection Personal Data Protection Day. I would like to keep you for some more minutes. Please give me these letters of thanks and the order of the Commissioner for the Human Rights of the Verkhovna Rada of Ukraine for active cooperation, for very important public activity and a very big contribution in the protection of human rights of Ukraine. And on the occasion of the International Personal Data Protection Day, the thanks are announced by the Commissioner for the Human Rights of Verkhovna Rada. I give it to Igor, the deputy head of the organization. Thank you very much. Also, please allow me to announce the order of the Commissioner for Human Rights of Verkhovna Rada of Ukraine for the big contribution to protection of human rights. Tatiana is given the thanks. Thank you very much for the assistance, for help and expertise. Thank you very much. I join you. Also, closing with what we started, Tatiana, in her opening word, she said that number 28 is magic. Do you know why? Because, of course, 8th January is International Data Protection Day, and 28th is the day of the right to know and have the access to public information. Maybe I spread my personal data, but my birthday is on 28th as well. And today we have a person who celebrates her birthday today, Lilia Alexeyuk, a very honorable expert of ours. And so on the behalf of the Commissioner, Lilia, please, sincere greetings to you with your anniversary, and you go with personal data for whole your life. Thank you for your friendship and cooperation and spreading of our efforts. Dear colleagues, thank you very much, and I declare this event closed and finished. Plus, I don't know what our capacities, but please taste coffee and cookies, and we have a good dinner, good lunch, and please communicate informally with your friends and colleagues. Thank you very much.